A recent decision by the Supreme Court of Appeal has given the Competition Commission new powers. It can now initiate a complaint against the company without having to follow the normal procedural formalities that are required of private complainants. Joining us now to explain what all this means is Paul Kutzer, who's Head of Competition Law at Worksman's Attorneys. We have this thing called creep or drift. We start at one place and then a little bit further down the line we wake up one day and say, my goodness, things have changed a lot. We are hoping to speak to Simon Sussman in a little while, the chairman of Woolworths, who has been outspoken about the way that more populist legislation is coming in and affecting business. This development, although on the surface might seem not like a huge jump, has to be of concern to companies because they can now get investigated without even knowing about it.
Yes, indeed, Alec. This judgment follows a long line of cases where the Competition Commission's wings have been clipped. As you know, they've been particularly successful with cartel investigations, but about 5 years or so ago in the milk cartel, they hit a roadblock where the Supreme Court of Appeal in Bloemfontein actually said that if a complaint is lodged, the Commission is stuck to the four corners of that complaint and they cannot go further. In this particular case, the Omnia case, however, the Supreme Court of Appeal has now, after 5 years, said that leave that aside, leave the original complaint aside. The Commission can, off its own bat, initiate an investigation, and they can do so tacitly, informally, without filling out any forms or anything like that, and without even informing the firm that's being investigated. And then after the investigation, start prosecuting them for the conduct.
The implications are horrific. You could have one day the competition authorities arriving at Sasol, I suppose they have had their problems,
yes,
but arriving at Sasol unannounced. Can you imagine what international investors would think about that kind of an issue?
Well, I should say that the competition authorities throughout the world have also got very strong powers, but there are strong checks and balances, and typically they can be curtailed. This judgment, however, I think signals that the checks and balances can only kick in really when the matter is referred to the competition tribunal. But then, of course, the company had already been exposed to huge reputational damages.
Just on that, you mentioned that other competition commissions internationally have stronger powers. Are we lagging behind them, or was this one of the motivators for this new change?
I don't think that we lag. I think that we are on a benchmark with international competition authorities. Our competition authorities have actually been very successful. The construction cartels that have happened recently and that have been prosecuted and where firms have been exacted to very high penalties is evidence of that. But the question is, how do you exercise your power? And do you not overstep the bounds of your powers? And that is the critical portion.
This whole thing about populist legislation, which Sussman's talking about, it's almost like he says that government has this naivety when it must realize where the money comes from. The money comes from businesses. And drift, as we were saying earlier, it just gets more and more difficult to do business. This might qualify as one of those issues.
Well, look, I think one should put it in proper perspective and have balance in this debate. And that is that the competition authorities are necessary, and they're necessary to ensure that the playing fields are level and that people do not form cartels, exploit the public and effectively crook and change and break the rules. So the rules are there for a good economic reason, and that is that people have to compete fiercely. However, it is how far the competition authorities take that and whether they exceed the bounds of proper regulation. As we all know, South Africa is a very heavy regulated country, and so for a foreign investor to see that when he comes in there's another level of regulation may be intimidating. On the other hand, he might know that if he wants to establish a new business against an incumbent that has a dominant position, at least there are rules in place which can assist that investor.
There's commentary here that the investigations will work on a wink and nod reason for investigation. How will the Competition Commission handle not following investigations from people who just have a bone to pick with the
Yes,
companies.
well,
unnecessarily.
that is indeed a concern, and the competition authorities will have to be very careful not to be swayed by people that are using or abusing the process in order to get an advantage in the competitive market space. So, but there is potentially a person that is an anonymous complainant that doesn't have to put his name forward, and that the Commission doesn't have to inform the company that such a complaint is lodged by a person with a gripe. And they've got to be very careful.
Well, we do know that we have a bad history in this country, that we certainly weren't the most competitive corporate environment on earth. But how much progress has been made?
Well, I think that's the challenge. We've had this competition legislation now for the past 13 years, and it's time now, I think, to be tested to see, has there been a positive effect, or has it just been another layer of regulation? The Competition Authority must go out there, and I think they are doing that, to try and see where they have intervened in markets like the milk market, like the agri-processing market, steel market, for instance. Have they been effective? Have prices come down? Are there more competitors in the market? And is there more innovation in those markets? I think as we sit here, it would be difficult for us to judge. It has to be subjected to an empiric test.